A mother sleeping in bed with her 3 children brutally killed while they laid beside her. At first glance, it seemed like a home invasion, a random act of violence. But as detectives dug deeper, they uncovered something far more sinister. Florida police say this wasn't a break-in gone wrong, it was a setup. And the mastermind? Allegedly the father of the victim's 3 children. Now, both he and his alleged accomplice are behind bars, and the 3 innocent kids are left without either parent. I'll walk you through the details. For Law and Crime News, I'm Kennedi Walker. To understand this case, we have to go back to January 23, 2024, the last day anyone would see 30-year-old Porshe Streeter alive. Sometime during the night, she was shot, executed in cold blood, shot a total of 10 times. Her 3 children were just inches away, untouched physically, but forever scarred. When police arrived, they found 2 shooting victims. Porshe, who was pronounced dead at the scene, and her boyfriend, Sean Range, who had been shot in the arm. Range told deputies he had come to check on his family when a masked intruder broke in, demanded money, and shot both him and Streeter. But something wasn't right, and as police pressed him for details, his story allegedly began to unravel. An arrest affidavit later revealed that Range and Streeter's relationship was toxic, allegedly marked by domestic violence. They had known each other since high school and shared 3 children, but they did not live together. Range would occasionally spend the night, but the relationship was reportedly far from stable. When deputies first arrived at the scene, they asked Range who was in the bedroom. He told them it was Streeter. They asked him if she was okay, and he reportedly said, "She should be, I was just talking to her." But when deputies opened the bedroom door, Streeter was already dead. Investigators noted that her wounds were covered in dry blood, and her body showed signs of decomposition. An autopsy later confirmed that she had been dead for hours before Range ever called 911. So if they were shot at the same time, how did Range have fresh blood from his own wound, but Streeter's blood was already dried? Now police are beginning to think Range could have staged the shooting, potentially calling in someone to help make it look real. According to police, Range repeatedly told deputies that an intruder was the one who killed Streeter. But after a year-long investigation, analyzing hours of surveillance footage, the Orange County Sheriff's Office said it was Range himself who pulled the trigger, allegedly murdering Streeter while she laid in bed with their children. And he allegedly did not act alone. Benjamin Garman Jr. is accused of helping orchestrate the killing, working with Range to stage it as a home invasion. Detectives now believe that after executing Streeter, Range waited hours before calling for help. Then, to sell the alleged lie, he had Garman shoot him in the arm just enough to make the reported robbery look real. Investigators reviewed security footage from the morning of the murder and saw Range picking up Garman. He then drove to the apartments where Streeter lived. Shortly after the shooting, Garman was caught on surveillance sprinting away from the crime scene the same way he came in. Authorities say both men later gave inconsistent and inaccurate statements about their whereabouts that night, and it was enough to put the final pieces together. Now, both Range and Garman are behind bars, charged with murder. And joining me to talk more about this is Florida attorney Melba Pearson. Melba, thank you so much for coming on today. Let's just dive right in. Will both men be tried together or separately? And what are the pros and cons of either option?
Yeah, so again, thank you so much for having me on. And it all depends. I hate to give that legal answer, but it does depend because we have to see if moving along in this situation, if they start to make statements against each other. So for instance, will the co-defendant say, listen, main defendant was the mastermind and I'm willing to testify against him? If that's the case, obviously they can't be tried together. If either of them give basically inculpatory or basically incriminates the other person, they can't be tried together. But if they both keep their mouth shut, which is unlikely, but hypothetically, if they both, maintain their right to remain silent and don't make any statements against each other, then you can try them together. I think there are some pros and cons to whether or not you want to try them together. It's very strategic. You have to look and see where you have the strongest evidence. What's going to be critical is text messages and other communications between the 2 defendants. Was this something that was planned and that the co-defendant was part of the planning process? Was it something that they just got called, the day of, hey, come ride with with me, I'm going to do this thing, or help me out, I have this situation. And so all of those things are going to play into who do you have the strongest evidence against. And if hypothetically, if the evidence is not super strong against both of them, you may want to try them together just so that they're evenly yoked, for lack of a better word, in front of the jury. Everybody can basically say, oh, you guys did this together. So there's that psychological aspect in deciding whether or not to try them together as well versus trying them apart.
Right. And just wondering, going further into that, is there a chance of either of these men basically negotiating a plea deal if they accuse the other one of being the mastermind, like how you mentioned, behind the whole plan?
Absolutely. This is going to be a race to the courthouse, as it is with basically every co-defendant case. People may be like, I didn't quite sign up for this, or I thought I was just kind of giving him a ride. I didn't realize he was going to, I didn't sign up for no homicide. And so they will very easily flip and say, listen, this was all his idea. We're looking at first degree murder. This is a life felony, made the death penalty eligible because of the presence of the children. That could be considered particularly heinous, atrocious, and cruel. So, with that on the table, it's very likely that the co-defendant will very quickly testify against, the boyfriend, the ex-boyfriend. And, I think that's how it's likely going to play out, where that person will plea, and then potentially the other main defendant may plea as well. Again, if death is on the table, that changes the whole calculus in terms of the level of risk at stake when it comes to trial.
Could that really work though? Because, think about it. They got arrested a little more than a year after the incident happened, after that death occurred. Could that happen to where one of the guys, the accomplice says, "Hey, no, I actually didn't know that this was going to happen," or would police say, "Hey, well, you had a year to report that"?
Well, I mean, that is definitely one of the issues that will be raised to that particular defendant. But again, at the end of the day, if you're going to admit guilt and if you're going to give key testimony to be able to move this case forward and to bring closure to those children and that family, listen, that plea is going to happen. Period. End of story. That plea is going to happen. And with the main focus being on the true mastermind, which is the abuser. There's that history of domestic violence. There's that history of threats and the friends and family speaking about this. And there was even, to my understanding, photographic evidence showing that there had been prior abuse. So that person is going to be the main focus of this entire trial. And the co-defendant, the accomplice, is more of just almost like a supporting character in some ways to ensure that this person goes away for the rest of his life.
What kinds of psychological evaluations, if any, might be ordered for Range or Garmin during the legal process?
I don't necessarily see mental health being an issue in this particular case. I don't see a situation unless one of them starts to challenge competency and say they didn't really understand what was going on or that they can't understand the legal process. But I have not seen anything that indicates that this is something that would be a major issue. Yes, they could be evaluated for competency, but there's nothing here that's telling me that they're not going to be competent to stand trial.
Could the friend Benjamin Garmin be charged with first degree murder even if he didn't pull the trigger on Porsche? Like I know we mentioned if they potentially get tried together. Could that work for him even though he didn't physically kill her,
Yes,
allegedly?
it could. Yes, because it's under the theory of basically what we call the principal theory. So, in other words, if you gave material assistance for this homicide to occur, and not just, oh, I answered the phone, whatever, or I gave somebody the ride I didn't know. It's more like, did you participate either in bringing him to the scene with some communication, knowing what was going to happen, picking him up, hiding him from law enforcement, trying to help cover up the crime? Those are all things that will get you charged as what we call a principal to the offense, meaning that you are too facing first degree murder charges because you basically assisted in having this crime occur.
Now, according to court documents, police stated that they started to get a little eerie. They felt like the story was starting to unravel when they asked Mr. Range just more questions specifically, and he claimed that he had just spoke to the victim, but the autopsy results said otherwise. It was said that she had potentially died hours before, that there was dry blood around her. How damaging is it for the defense that he claimed that he had just spoke to her?
Highly damaging, because now when you have a situation where you're lying and you're caught in said lie, that does not look for your good for your credibility. And also, his statement clearly is opposite to what the evidence shows. And so again, it shows his attempt to cover up the crime, and that shows that consciousness of guilt, which really speaks to his mindset, and that's something that is going to weigh very heavily in the jury's mind when they're deliberating.
How does staging a murder as a home invasion impact sentencing if convicted?
I wouldn't say that it impacts sentencing per se, because it's not something that's an aggravator or anything along those lines, but it does impact the arguments that would be made at sentencing. Like, listen, not only did he commit this heinous crime, he tried to basically frame another person, say some other dude did it. Somebody came into the house and, killed my partner and tried to injure me. So that attempt to cover up the crime again shows that consciousness of guilt, shows that this wasn't an accident. This wasn't, some other explanation. This was something that was planned and that he tried to cover it up. So I think that's something that would be used as an argument to say that this person should get the maximum sentence.
What role does motive, like domestic violence or, alleged relationship issues, play in building the prosecution's case?
It's going to be critical, because the reality is, even though prosecutors don't necessarily have to prove motive as one of the elements of the crime, juries want to know why. They want to understand why something happened. And if they can't get their mind around what occurred, it makes it so much harder in the jury room to get to that conviction. So it's going to be very critical to talk about the domestic violence so that people understand the escalation, understanding and bringing in what we call prior bad acts, where previous instances where he abused his girlfriend, again showing that this isn't a one-off, this wasn't an accident, this was a common plan or scheme. She was trying to leave him, or she was trying to get full custody of her kids and wasn't giving him money and these types of things. Well, if you're seeing that abuse all along the way, and that he's been maintaining this control over her, not allowing her to have autonomy, not allowing her to really leave, this all speaks to his motive. And again, it really shines light on why he did what he did and why he had to cover it up in the way that he did.
And we touched on this a little bit in the beginning. The victim's children, who was also Mr. Range's children. Police are saying that, Mr. Range allegedly killed the victim while she was laying in bed with their three children. Could Range face additional charges for endangering the lives of his own children during the crime?
Yes, he could. Now, filing it is more of sending a statement than anything, because again, first degree murder is a life felony, or could be death penalty eligible, depending again on the facts and how what the prosecutor thinks in terms of the way forward, as well as what the next of kin wants. Because again, that's something that has to be weighed in. If the family is very strongly against the death penalty in this case, that is something that would be part of the prosecutor's calculus.
But could the fact that the children were there during the murder allegedly be considered an aggravating factor under Florida law?
Absolutely, absolutely. But my point is that you don't necessarily have to charge that, because a child endangerment or those sorts of charges are like maybe third degree, second degree felonies, depending. When you already have a life offense, it's more you're adding that almost as
Right,
gravy, just to kind
gotcha.
of explain and add more, but it's not really necessary, because you're already seeking life or you're seeking death. Everything else
True.
is sort of like, okay, and then we're going to add another 5, 15 years. It's sort of like, I always feel when I was a prosecutor, I like to keep my charging document clean, keep it as straightforward and to the point, so there's not all these other extra charges that now the jury's like trying to chase down all of these different rabbit holes, rather than just focus on the main thing. He murdered his girlfriend in front of her kids. End of story. Let's send him to prison for life.
And what typically happens to the children in cases like this, when both parents are gone?
It all depends on the family structure. If they're blessed to have grandparents or other relatives that are willing to take them in, then that may be an option. If not, then unfortunately they may end up in the foster care system, which is, a whole nother pathway that is not doesn't always necessarily end well in terms of the children not getting the support that they need, and unfortunately maybe being exposed to certain elements or aspects that may lead them down the wrong path moving forward. So hopefully there's family that can step up and take them in.
Right. So heartbreaking, just all the way around. Could the children be called as witnesses in any capacity at all?
They could, but if I was a prosecutor, I'd shy away from that because the level of trauma and guilt that they may already be experiencing, and again, the guilt aspect, rightfully or wrongfully so, as human beings, we sometimes feel, that, oh my gosh, this was my fault. I could have done something. I should have protected. And especially a child who's struggling to kind of understand all that's happening. It's just, yeah, I would not want to re-traumatize. I think the oldest was 10. I don't think I would want to put the 10-year-old on the stand because that's just too much. And if you have other evidence to be able to prove the case, I would shy away from doing that. It doesn't add anything.
Could the defense call the children?
They could. I don't know what they would try and get from the children. I mean, unless it's like, oh, were you sleeping the whole time, or did you hear somebody come in, or something along those lines? But I don't think there's enough meat that the defense would want to hang their case on the testimony of the 10-year-old child.
Are there any legal protections in place to shield the children from the public spotlight during court proceedings?
Absolutely, because of the fact that they're basically next of kin. I mean, and they're also the survivors of crime, and being underage, they would be most likely be referred to by their initials rather than their full names. Usually, when it comes to coverage, whether it be media, whatever the case may be, the children's faces may be blurred. Additionally, depending on the situation, a guardian ad litem may be appointed to look out for the children's interests in terms of, let's say if there's a request to have the children testify, somebody kind of intervening, or again, just kind of being that voice for the children in the courtroom.
And you've been doing this for a long time. Is it common for suspects to allegedly stage a crime scene? And how do investigators typically uncover the truth?
It's not that unusual to have a defendant stage a crime scene, but again, what the law enforcement needs to do is just follow the evidence and figure out, whether or not the story makes sense in the whole course of events. I mean, because many times we'll see situations like, oh, I'm going to fake, I'm going to stage this as a burglary, and then you break the glass, but you break the glass from the inside out. So the glass is all outside versus inside of the house, consistent with inconsistent with somebody trying to break in, right? So there's always these little clues that people don't quite think through, especially because you're under the stress and the adrenaline of committing a crime. A lot of people think, oh yeah, I can just do this and it'll be fine. No, your brain goes into like high gear, and you just start to, do these gut reactions that may not necessarily help you in terms of trying to cover up the crime. So in other words, you eventually end up telling on yourself in one way, shape, or form.
What kind of defense could Mr. Range's legal team realistically present?
Realistically, because the reality, and I chuckle at this because the Constitution entitles you to a defense. It doesn't mean it's a winning defense. It doesn't mean it's a defense that's going to make sense, but it's a defense. So I would think they would try and go down with the ship and just say, listen, this was a home invasion. The police rushed to judgment. There was improprieties in the way that the crime scene was handled, something along those lines. They didn't chase down all the leads. That would be the kind of direction the defense is left with going in. But again, with all of that domestic violence history, it's going to be an uphill battle.
And so, if you were the prosecution, I'm sure, what do you think it'll be, an open and shut case? What would you do?
I think it would be pretty straightforward. But again, looking at what the next of kin, the family members want, they may not want to go through a trial. It may be, again, too traumatic and they're trying to help the children and help rebuild their lives. So a plea may be appropriate in this case. I mean, again, it all sort of depends on how the facts shake out, what the family wants, and what makes the most sense. So this could be a situation where it could be a 25-year, 30-year plea, or this could be trial and, resulting in all likelihood in a conviction. Of course, you never know what a jury is going to do, but based on the facts that are publicly available at this juncture, I would have confidence moving forward, and getting a guilty verdict.
What message, if any, does this case send to the public about planning crimes and trying to outsmart the system?
Well, you know what? Like I always joke that, we don't always catch the smart ones. The smart ones are on a yacht in the Riviera. So, the reality is you can't really get away. You think you've planned every single aspect, but there's always something you're going to miss, so don't bother. But more importantly, I think this horrible tragedy really puts a focus on the scourge of domestic violence and the fact that, listen, you've got to get out. You've got to get out. If you or somebody is being impacted by domestic violence, whether, and it impacts all genders, it impacts all socioeconomic groups, races. Nobody has the monopoly on domestic violence. And so if you or somebody is involved in this kind of situation, please get out. There's resources available. There are people that will believe you. Don't stay, because unfortunately, these types of situations very rarely end well.
Absolutely. And we're hoping that this case and this story saves at least one life. But I do have to ask you one last question before you go. This has been a very highly publicized case. Is there a chance that this could be moved to another jurisdiction due to the media attention?
It's possible, but unlikely, because of the fact that this is not, for instance, you're not trying a celebrity. You're not trying somebody, it's got to be the kind of situation where you have to be living under a rock to not know about this particular case. And I don't see that to be the situation in terms of the coverage. I think it's one of those things where there's a lot of coverage now, but a year from now, 2 years from now, the potential jury pool may not remember the case. And it may be pretty easy to find a juror that can be fair and impartial, and it does not have a preconceived notion with regards to guilt or innocence in coming into this case.
Great. Well, thank you so much, Melba, for coming on. We appreciate it.
Thank you so much for having me.
Neither man was granted bond. For Law and Crime, I'm Kennedi Walker.